Hi, I'm Paula DeMann, an attorney at Ambler Law Offices, and I'm here today to talk a little bit about theft or larceny-related offenses in Virginia. Larceny is defined as taking the property from the rightful owner with the intent to permanently deprive the owner of that property. When the value of the property is below $1,000, that is a Class 1 misdemeanor offense in Virginia and carries up to 12 months in jail and a $2,500 fine. When the value of the property is over $1,000, that is a felony, grand larceny, and can carry up to 20 years in prison. When the offense occurs at a business, we commonly refer to this as shoplifting, and that can occur in a number of different ways. For example, if someone switches price tags or fails to scan items at self-checkout, they can be accused of shoplifting. Now, people charged with these offenses typically come to us in two different categories. First, there are people who acknowledge that they committed the offense and they're trying to figure out how to minimize the consequences. The good news is that in Virginia, a law was recently passed allowing people who have been charged with a larceny-related offense for the first time to be placed on what's called a deferred disposition. A deferred disposition is where the judge makes a finding that the facts of the case support a finding of guilt. However, and this is the important part, the judge will not find the person guilty at that time. Instead, the judge will continue the case and withhold their finding and require a person to comply with certain requirements. So for example, that person will have to be of good behavior for the period of the deferral. They cannot have any new criminal charges against them. They will often have to pay court costs, which are administrative fees assessed by the court for the cost of the prosecution. Sometimes they will have to complete community service hours. Sometimes they will have to complete a shoplifting class. But the end goal of a deferred disposition is ultimately to return to court and have the charge be dismissed. Now, sometimes people are accused of a larceny-related offense and they contest their guilt. They are wrongly accused. Oftentimes, defenses of larceny-related offenses hinge on whether the requisite criminal intent existed. For example, say you're checking out at Walmart at the self-checkout. Your cart is full of items, you have your kids with you running around, you think you've scanned everything, but you miss a couple items at the bottom of your shopping cart. You go to leave the store, loss prevention shows up, and they accuse you of stealing from Walmart. There, the defense would hinge on, did you have the criminal intent to steal those items? And that is something that the Commonwealth has to prove beyond a reasonable doubt to find you guilty of the offense. So if you or a loved one has been accused of an offense like this and has any questions, please call us at Ambler Law Offices at 540-550-4236.